righty. Hello. Welcome back to yet another episode of Empowered Esquire TV. This is the first installment in our series EE Reviews, also known as Empowered Esquire Reviews, right? So, in this series, I will be reviewing videos, sometimes from YouTube, sometimes from other places, sometimes recommended by you, but sometimes just related to topics that we have already covered, i.e., following up on them, right? Or, of course, some sort of relation to our mission of empowering you with legal knowledge. So, anywho, how are you? I hope you are well. So, first up on our EE review checklist is to discuss former NFL player Zach Stacy. Now, a video of his, I believe, first court appearance in the matter was recently uploaded to YouTube. And I asked everyone in my community tab, hey, do you want to talk about this? Would you like to see me talk about this? And you all said, yes, you would love to see me talk about or rather review, I should say, the Zach Stacy court appearance. So without further ado, we're going to get straight into it. Listen, this is a pre-recorded video, right? Which means that although I am not live, you can still chat. You can still, of course, post comments, and I will, of course, still be in the comments responding to your thoughts, your questions, and your concerns. Alrighty? Okay. So let's get into it. I'm going to share my screen. I'll, of course, stop it as we go along. You know, I always announce that I'm sharing my screen. All right, let's see how we're looking. Good. Wonderful. Okay, let's get started.
What happened? The judge set a bond of $10,000 on count one, $150 on count two, ordered no contact, ordered that you file your passport with the clerk's office. You posted the bond, you filed the passport with the clerk's office, and you were released. I said this hearing in very short order. I understand you're residing in Tennessee. You came for the hearing. The purpose of bond is to assure your appearance in court, and I'll note that you've appeared on short notice today for the hearing. The state has filed a joint motion to reconsider the bond and to allow the alleged victim to testify. That's the motion we heard.
All right, so let's take a moment right now for me to break down what's going on in this moment. So what we have heard from this judge is a summarization of what has occurred in the case and why they are there. Now, this is a very thorough judge just from the way that we're seeing him proceed, right? Because it is not always that judges do give this sort of summarization. And this summarization, I say it's particularly thorough because that means that if someone were to pull this transcript, the judge has given that person, the transcript reader, transcript reviewer, if you will, a very clear idea of what has already happened in this case. So the judge says that former NFL player Zach Stacy was previously charged in this matter, that bond/bail was set on each count, and that a no contact order was issued. Now, let's talk about no contact orders. What is that, you might be asking? Well, it is an order issued by a court which says that a defendant is not permitted to contact a certain person and or people. No contact orders have different names in different jurisdictions. So, for example, in the state of New York, no contact orders are usually referred to as orders of protection. In some states, such as California, a no contact order might be referred to as a restraining order, right? So different names in different jurisdictions, but really it just means the defendant is supposed to stay away. So we know that Zach Stacy has been ordered to stay away from probably his girlfriend and perhaps the minor child as well, but we're not sure on that. Wait, one more thing I wanted to mention. We also know that the prosecution has filed a motion to reconsider bail, meaning they have probably filed a motion asking for a higher bail. So we're going to hear about that now.
State, if you wish to make an opening presentation, I want you to know, as well as Mr. Luke, that I've listened to the proceeding that occurred at initial appearance twice. First, when I received the motion, just to
And the
understand
sound is
better.
kind of sketchy. You can hear the
Second,
sound going
refresh
in and
my
out.
recollection.
So we may have some
Fully
difficulty.
advised as to what happened at the hearing. If you would like, I'll take judicial notice of that.
We would request that.
Okay, that will be done, and how would you like to proceed?
And the purpose of this motion is really to receive the information that the state had not received at the time, and that was input from the victim. She had planned to be there at.
So the prosecution wants the victim to testify.
The case was moved out with a little notice.
Yes.
So the point is really just to implement proper safety mechanisms and to just ensure that the victim's safety in this case.
I understand.
So we would like to inquire about the address of the defendant, who he's going to be living with, the firearms, are there any firearms? I know he cannot possess it, but does his roommate, does he possess any firearms? Just things of that nature.
Okay, fair enough.
So it seems like prosecution also wants to get more of an idea as to whether or not the defendant might have access to weapons and what his living situation is. It is very important for the prosecution to ascertain this information because they need to make sure that Zach Stacy doesn't have access to any weapons which he could use to possibly come after the victim, the alleged victim.
Would you like me to inquire of Mr. Stacy of that? Yeah?
We would.
Okay. Mr. Luca, I'm going to ask your client questions. He's under oath. If you object to any of those questions, feel free to object. I will not be offended. Okay?
Can I just, I'm sorry, Your Honor, can I just make a quick opening statement to address some of those issues?
Sure.
Thank you, Your Honor. Your Honor, just to, and for the state's what noticed as well, I filed this morning with the clerk to change of address. Yesterday, I filed a motion, or a response to the state's motion. Mr. Stacy is set to enter into a mental health inpatient treatment facility in Colorado, Edwards, Colorado, starting December 1st. However, between now and December 1st.
So as you can hear, Mr. Stacy is set to enter into a mental health program. Now I have an interesting question for everyone here. Do you think that Mr. Stacy entering a mental health program could at all be helpful to his defense? Do you think that he genuinely has mental health concerns, or do you find it intriguing? Do you find it curious that after these charges, he has now decided to enter a mental health program? This sound is not good at all.
In Alabama, and I filed a notice of change of address. When I cleared this with his probation officer, she has no objection. Or she's not probation officer, bail, but bail has no objection.
Right.
So I did put that in in my response. But I have no problem with the court requiring us to clients where he's going to reside, but it will be in Alabama, it will not be in Tennessee. He's not only possessing firearms, but I have no problem with the court requiring that.
Okay. So State, have you received a copy of the notice of change of address indicating the address in Alabama?
Yeah.
Okay, here's a copy of it. It's been filed with the clerk, so you'll have access to it. So we have the answer to your first question. Okay, Mr. Stacy, I'm going to ask you some questions. You can stay seated. You're under oath. And I just need you to speak loud enough for me to hear you. Can you do that, sir? Sure. Okay. So I have an address of where you're going to be residing in Alabama. Is that with your mother?
Yes, sir.
Who else resides there with your mother at this time?
My little brother.
How old is your little brother?
He's 24.
Okay. And how old are you?
I'm 30.
So Zach Stacy's mother will have her two adult sons in the home with her from Zach Stacy's testimony.
To your knowledge, are there any weapons in that or firearms in that house?
No, Your Honor.
Okay. A condition of your release is that you not possess any weapons or firearms. You understand that?
Yes, sir.
Violation of that condition can result in your incarceration, most likely not another bond set, although I can't promise that. it would be a bad situation. You understand? Part and parcel of that is you cannot be in a house with firearms. So if there are firearms in the house that you become aware of, or you make a phone call to your mother right after this hearing, they need to be removed from that household because I don't want you residing in a house with firearms. You understand? Yes, sir. You follow that condition? Yes, sir. Your attorney just informed me that you intend to enter a program in December in the state of Colorado. Is that correct? Yes, sir. Is that an inpatient program? How long is that program? 30 days. Then you would be out presumably at the end of December, maybe January 1st, even depending on how long 30 days is in their opinion. When you get released from that program, where do you intend to reside?
Just go home to back to Alabama.
Back to Alabama.
Place of residence.
Okay. So if I order that except for the time that you're in participating in the inpatient program, you will reside at the Alabama address you just provided, you can comply with that. If you wish to move to another address, you're free to do so after your attorney files a motion, and I approve that. I just want to know where you're living. And you understand that there's a condition you have absolutely no contact, either directly or even indirectly through your mother, brother, family members, or friends with the victims. And you can comply with that as well, correct? State, is there anything else you'd like me to inquire? I think I answered all the concerns.
Judge, if you could also inquire, he also has a residence in Orlando.
Okay.
So let's take a moment. You heard bail conditions, right? Which, as we have discussed here on this channel before, i.e., Brother Polite or Kelly, right? When bail is granted, there are always conditions. And if those conditions are not met, then the bail can be revoked. So the judge was very clear with Mr. Stacy in telling him it is a condition of your bail that you not have any weapons. If I find out that you do, it could mean that your bail would be revoked, right? So bail conditions are conditions by which a defendant has to pretty much live by while they are being allowed to be a member of the public via bail, okay? Now they're getting into whether or not he maintains another residence in Orlando. So this prosecutor is very sharp, right? She has caught on to the fact that Mr. Stacy seems to be stressing that he will be living in another state because, you know, let's be honest, it looks better for him in terms of bail to say that he'll be so far away from the victim that he'll be of no danger to her. So the prosecutor has picked up on that and she has thought, well, let me clarify that you don't also have a place that you could reside in Orlando.
The location where this occurred was, I believe, an apartment. Is that apartment in your name?
No, sir.
Okay. Do you have any leases? Or do you own any real property first in the state of Florida?
Yes, sir. I have a lease.
Okay. Where's that lease?
It's at 55 West Apartments on Church Street.
Now, we got into the crux of it, have we not? So although Mr. Stacy is representing that he is going to be living in another state, nowhere near the victim, making him much safer for bail, right? Much safer for release. It has now come to light that he has a lease on an apartment in Orlando. Interesting.
And are you planning or do you intend to return to that location?
No, Your Honor.
Okay.
Counsel for the victim would like to speak prior and present a statement as well.
Okay, I understand. Is there any other information you would like me to obtain from Mr. Stacy? For the statement. Okay. Thank you, Mr. Fire. If you'll stand and approach the lectern where there's a microphone and whatever you wish.
Good morning, Your Honor. I'm Tom Fire, Satisfaction Counsel for Kristen Evans here. As I'm sure the court's aware, under 1 Section 16 of the Florida Constitution.
So in some instances in which you have a case of either DV or familial violence of some sort, the actual victim, his or herself, will be granted an advocate or attorney of their own. And it sounds as though this is one of those instances. This young man has introduced himself as the attorney for the ex-girlfriend / alleged victim in this case. And it appears that he's about to read a statement from her. Now, if you're wondering why this is relevant or why this is even being permitted to happen, it's very likely that the prosecution is requesting that the judge consider this victim statement in, i.e., the bail being set and the bail conditions.
Constitutional amendment states that victims have the right to have their safety and welfare, as well as their families, considered in setting bail, including setting any pretrial release conditions that could affect the safety and welfare of the victim. Ms. Evans has not yet been given that right. We appreciate the court giving her that opportunity here this morning. So with that, I'd like to call President Evans. May she stand for the next meeting to give her statement.
Is she more comfortable standing there next to you?
I think she would be best for her.
And you'll come up to the
Oh,
left of
so
your
it
corner.
appears that she's actually going to read the statement herself.
Raise your right hand or hold your right hand to the safety and address.
Please solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes. Thank you.
Put your hand out, tell me your full name, please.
My name is Kristen Evans.
Okay, thank you. You may inquire into your life.
So Ms. Evans, I understand you have a statement that you prepared, a few things that you want to share with the board this morning, is that correct?
Yes.
Okay, you may, of course, share.
Thank you, Your Honor, for being here today. I am the victim in this case. I have a 12-year-old and a 5-month-old that I am hiring caregiver for. You've seen the video, what he did to me. I was slapped, punched, literally picked up and thrown into my TV, and then picked me up and slammed me into my son's bouncy seat by my throat. This is not the first time that he's been violent with me. I am afraid for my safety and for my children's safety. He was released on the weekend, and I was too afraid to go home. I have not been back home yet. My injuries from this incident are serious and likely permanent, from what I have been told. I'm just asking the court to increase his bond, place him on home confinement, and make sure, and verify his residence, and make sure there are no firearms.
Okay. I believe from the report you were concerned, it might have been in the injunction request that you might have had a fracture, and you went to the hospital, as I understand it. Is that correct?
That is,
To your knowledge, was anything fractured?
yes, sir.
Okay. You've been home since this incident? Or you have not?
I have only been home to grab items with police escorts.
Okay. Have you had, or let me rephrase that, has Mr. Stacy had any contact with you since you've been released?
Yes.
And you have a relationship with his mother?
Not any longer, sir.
Okay. Thank you. Anything else, Mr. Potter? Any other questions?
No further questions of Ms. Evans, just some.
So there's some key language in here that I want to point out to you. So when you hear Ms. Evans say this is not the first time, remember the magic word on this channel, pattern. Remember, a pattern is the only way by which you can get things that someone has done in the past and bring it into the current case. So when she says this is not the first time, she's helping the prosecution take that step towards a pattern of behavior, which they probably will try to discuss and bring out at a possible trial. She then mentions that to her knowledge, her injuries are severe and will be permanent. Again, that lends to the severity of the injuries here, which goes directly to how severe this incident actually was. And all of these things are things that a judge can consider when deciding bail / bond.
Remain here for 1 minute. Mr. Luca, do you have any questions?
Very briefly, Your Honor. This happens, I don't want to talk to you back. Isn't it true that you the time of the original incident that occurred, and, today, there was an intervening car accident you were involved in?
That is incorrect.
All the questions I have, Your Honor.
Okay, thank you. Mr. Fire, any follow-up questions?
No, Judge, thank you.
And State, do you have any questions?
Yeah.
Okay, thank you. Anything else, Mr. Fire?
Yes, just very briefly, Your Honor, if I may. Your Honor, it's our argument that the defendant is violent, he is dangerous, you've heard from Ms. Evans, and you've seen some of what he's done to her. You've heard that she's feared for her life and life of her children. We consider him to be a very dangerous and violent man. After this happens, he fled the state. I'm asking the court to, we've already inquired of where he would be staying, who he's residing with. And we've talked about his local residence here that was not shared with the initial appearance judge. We're still unclear why he gave an address in Tennessee, but in the end, we're asking the court to increase the bond amount.
Interesting. Where'd the address in Tennessee come from?
Confinement for some measure of protection, so that if he is to leave the address that he just filed this morning, that our client is notified of that, so that she can be aware he may be returning to the state of Florida. Obviously, it's our preference that he doesn't return to the state of Florida. Or ask that where there be no firearms in any home he resides with, and continue to, as we have here today, respect the victim's rights. Thank you.
Okay, State, any arguments? I believe it's your motion.
No argument, we did coordinate our response. I would have to note, though, I do have to let the court know that the address that was given to the IA judge in Tennessee, there is some correspondence that we'd like to see that when he gave that address to the court, he actually was not allowed to be at that address. There is another party there was a custody order, and he was not allowed to be at that address. So that was just
There was a lot of.
So, another interesting thing. So, the address that Mr. Zach Stacy gave initially at his arraignment regarding where he would be staying was an address in Tennessee. Now, the prosecutor is saying that allegedly he's legally not permitted to be at that address per another court order. This all sounds like a pattern, allegedly.
Apparently that happened at that hearing, that was unusual, to put it kind of evaluate. Thank you. Okay. Mr. Luke,
Very briefly, Your Honor. The rule that governs pretrial release for Rule of Criminal Procedure 3.131 in order to change the bond conditions, the court must be made aware of new information that was not known at the time to the magistrate of the original initial appearance. For the record, last Thursday, so just so we're clear as to how these events unfolded, immediately upon learning that there might be a warrant, before even having a warrant was actually confirmed, Mr. Stacy retained our firm and myself to try and inquire as to finding out the warrant. Apparently there was some issue with how the warrant was initially submitted to the court, specifically the spelling of Mr. Stacy's first name, one letter off. He actually tried to turn himself in Nashville when he thought there was a warrant outstanding, but there was no warrant because it was under the wrong name. That was corrected by Detective Dozier on November 17th of the Oakland Police Department. He confirmed that with me at 4 o'clock. I immediately got on the phone with Mr. Stacy. He immediately flew and came into Orlando. The plan was originally that I was going to pick him up at the airport, meet Detective Dozier at the jail, and surrender him. However, apparently someone recognized him on the plane, and he was arrested and taken into custody by the Orlando Police Department.
Okay, so they're explaining the whole spiel as to why someone saw him on a plane and then called the police.
As far as the first appearance is concerned, that also is awesome because, again, when I was informed of the first appearance, that first appearance was going to be at 1 o'clock in the afternoon on November 18th, I got November 17th. The morning of November 18th, I received a call from Judge Baines, not the initial appearance judge's judicial assistant, indicating that they wanted to remove the pretrial function at 10 o'clock in the morning specifically because that is when the alleged victim would be available to testify. And that's the only reason why it was done. So it was not moved up because of me or because of anything else. It was moved up, as far as I know, because of Judge Baines and his understanding.
Does this not feel like when someone is telling you an extremely long story?
Or Mr. Stacy, I just want the court to be aware of how this was, you're right. So initially, there was not, again, I was not even given, there was not paperwork after the initial appearance to even review or time to review because of the quick turnaround we had. I had the court here before the judge at 9 a.m. and had to run immediately over to the channel to deal with the situation. So you're right, Your Honor, certain things were said in court that were unknown to me, however, they were brought to light. The injunction information was presented to
He's still speaking.
Judge Baines, so that was known to him at the time. He imposed a bond that is in excess of the standard bond schedule pursuant to Administrative Order 0798-4717 and the most recent one, 2003-3924, which sets the Orange County bond schedule. Plus, also additionally, imposed additional conditions surrendering Mr. Stacy's passport, which he did. He did provide that address because that was he only provided the address in which he was staying at his last known address, so that was the only address he had at the time. That's one of the reasons why we're finally changing that address.
Wait a minute. When the court asks someone where they live, it is not appropriate for them to just provide their last known address. So his attorney is trying to explain how he gave an address that he's not permitted to reside in to the court. And the explanation that we're hearing, if I'm hearing it right, is, well, he just gave his last known address. No. The question that is asked of a defendant is very clear. It is, where will you be residing? Not what was your last known address. So this explanation right here, after this 15-minute long story that we had to listen to, the dog ate my homework and then the cat. Oh, my. Beware that I will be sassier in these EE reviews than my typical persona. Okay. And I have to say, disclaimer, this is just me. This is just my personality. This is just my humble opinion. This is just my commentary. My statements, commentary, and opinions are not at all reflective of whether or not the people I am commenting on are competent, amazing, and wonderful people. Okay. I don't know them personally.
Yeah, we realized that because of this pending custody order that we were not aware of at the time, but since we become aware of, Mr. Stacy can't live there, hence he's now going to live with his mother in Alabama.
Who wasn't aware of the custody order? Who wasn't? Zach Stacy wasn't aware of the custody order, or the counsel, the defense counsel? People, I'm hoping this story is somewhere near its end.
Until he goes through the program.
Not aware of a custody order. Is that not your client?
Until he can use his own rights. So it's again not a fault of Mr. Stacy that this custody order prevented him from residing at that residence because no one knew that was actually an issue at the time. So
how could you not know? How could he not know?
From surrender to now, however, none of those was a fault of Mr. Stacy, and I don't think any additional conditions for bond are necessary, including home detention, or any sort of ankle monitor or anything along those lines. It's going to further protect this evidence from contact with Mr. Stacy. Mr. Stacy will be living 2 states away.
How long is this story?
And
story's still going.
December 1st, which then will be in at least 2,500 miles. So I think there's adequate safety precautions in place, and that the state, to satisfy the state and Mr. Fleming's client, that Mr. Stacy is not a her family, and anyone else, and he does not intend to return to the state of Florida until he has to Florida.
Okay, two states away. Part of Alabama, Florida are contiguous.
However,
let me ask you, and you made the statement, and it was going to be one of my questions, and I'm glad you brought it up. If I entered an order modifying the bond and prohibited Mr. Stacy from returning to the state of Florida except for court appearances, that's something that he could comply with?
Absolutely not. No problem with that at all.
Thank you.
I think it's to respond by me. To what Mr. Lizzie was saying, I don't know where he's getting his information, and I'm not saying he's lying, but the information he just provides to the court.
Pause. Did I not say, as we were listening to this story, did I not say, you know, this is the dog ate my homework and then he wouldn't give it back. And then it was a story that it did not ring true in all areas of practicality and common sense, right? Did we not say that? And now this counsel has said exactly that. He's not trying to say that the other attorney is lying, right? And let me give you a little insight, a little teaching moment. The word lying or liar is taboo in a courtroom. It's not permissible to just say someone is lying, to just call them a liar, right? That's very frowned upon. If you believe that someone is mischaracterizing something or misrepresenting something, right? Then if they are a witness, you can impeach them, which means you can ask to take their testimony and confront them with the evidence that you have, which proves that they're misrepresenting. And if they are your opposing counsel, you can submit that evidence to the court and say, well, Your Honor, we have evidence otherwise. And so it seems that professionally, that's what we're about to see happen.
It was not accurate. Our client, Ms. Evans, had planned on attending his initial appearance in person. He communicated that to the court personnel. For whatever reason, he moved up. She told him she was in the hospital, she was trying to be heard, and her voice was effectively silenced. So,
If she was, which is why we're having a hearing today. So
yes, sir.
all that has been remedied. New information I've heard that the initial appearance judge did not is her testimony. So I agree that that would provide information if I thought it was appropriate to modify the bond. Okay, thank you. Okay, Mr. Stacy, the purpose of bond is to ensure the safety of the community, and the primary purpose is to ensure your presence. Again, I gave your attorney very short notice for this hearing because I thought it was very important, and I thought that the victim should have her voice heard. It should have been heard on November 19th. It wasn't. We heard it today. I'm not going to modify your bond amount. I think the amount is appropriate only based upon your appearance today. And so I'm not going to increase the amount. I'm going to modify a condition of the bond that you not enter the state of Florida except when there is a scheduled court hearing, and that you not reside anywhere other than the Alabama address you provided where you reside with your mother, except for the time that you were in and participating in the inpatient program in the state of Colorado. Again, that's subject to modification upon motion, not upon you wanting to do it on your own. Does that make sense?
Sure.
And to be clear, you were to have no contact whatsoever, directly or indirectly, with, is it Ms. Evans?
Yes, sir.
With Ms. Evans in this case. Stacy, as you're aware, the Ninth Circuit not only doesn't have an ankle monitoring program, but specifically prohibits the ankle monitoring program from being used. So I cannot authorize that today. Are there any other conditions you think are necessary to the state of Virginia?
Just reference of firearms.
Okay, which has already been referenced, so I'm only modifying by adding, not subtracting any of the conditions. All the original terms and conditions of the bond set at initial appearance.
So the judge is making it known that the original conditions also still apply.
Yes, you very good thing. My client is performing the outside some property at 255 West address. We allow him to go to that address today, obviously, before we back to go to Alabama to get as much stuff as we can and file this car.
Okay, so you wrote down here, Mr. Stacy?
Right, John.
Okay, and is it your intent to leave today or tomorrow?
That's it.
Today, okay. You may remain in Florida. You can go to your address at 55 in the West Central. Is that what the address is?
55 West on Church Street.
West Church Street, okay. To retrieve your items with the understanding you're going to have no contact with Ms. Evans, not go to the location where this event allegedly occurred, and you will, on December 1st, participate in that program in Colorado. Any questions about what happened here today? Okay, anything else, Mr. Luke?
No, Your Honor.
Mr. Filer, anything else?
No, thank you.
Thank you all very much.
Thank you.
Thank you for addressing us at
All right. So we have reached the end of that video. As you all know, I'm still experiencing internet issues. There's nothing I can do about that. I promise you, my bill is paid. I have requested, Mac, bless you, Mac is sneezing, the highest band internet they can provide. And the issue I am being told, bless you, Mac keeps sneezing, is the area. I'm being told that for now, there is nothing that they can do. So I'm hoping that this pre-record thing will work and that perhaps when I upload it, it will be clear. But honestly, we're not sure. This is just a shot in the dark and a hope and a wish and a prayer, right? So we will see, okay? Anywho, I'll catch you next time. This has been another installment of Empowered Esquire TV. Of course, today we're doing something a little different. We're doing an EE review. I hope you feel empowered by the legal knowledge that I have shared today. And I hope you feel powerful and amazing because you are. So let me know in the comments, what did you think about this hearing? Do you think that this matter is proceeding in an effective manner? And were you surprised too when the victim's attorney spoke? Because I thought he was going somewhere else. I thought he was going down the path of why did Mr. Stacy give not so accurate addresses. That's the path I thought we were headed down, and then he went somewhere else. But, it is what it is. It is what it is. So, were you just as surprised as me? Because that's not what I thought was going to happen. Anywho, I'll see you next time.